By the way, do you hear me? No?
Yes.
Oh God, at last. Bingo. Bingo. Sorry. I don't know. It was something somewhere wrong. It was not just on off muting. Yeah.
You had a technical hitch.
Yeah. However, I am here now.
Thanks for agreeing to do some interpreting. That's really helpful. Cheers.
Thank you.
Right, so it's 5 past, so I think we can make a start. So welcome everyone to this morning's session. We're going to be talking about asylum rights, immigration law, and we've got LawStop here who are going to be leading on this. So as I said before, just to let you know, we are also streaming the session on YouTube. And we also have Rizgar here, who is one of our refugee resettlement workers. If you need Arabic interpreting, he's available and he's kindly volunteered to support us with this. What we're suggesting, if you do want something translating, could you raise your hand using the hand button at the bottom of the screen? Rizgar, I don't know if it's worth you translating those instructions.
Yeah, thank you.
So I'll hand you over to Gary from LawStop. Thank you so much.
Thank you, Sophie. Thanks. And hello, everyone. Thank you all for joining us today. I'll start with introducing myself and the firm, and then we'll move on to the presentation which Sophie's just kindly put up. So my name's Gary Goddard. I'm an immigration caseworker. I've been an immigration caseworker for about 16 years now, and previously worked for the Refugee Legal Centre for many years, and more recently Citizens Advice Southwark in Southeast London. For nearly a decade as a specialist immigration advisor. I've more recently joined LawStop since January of this year. Now, LawStop are a firm of solicitors who do a lot of housing work, under legal aid, community care work, education law work, and public law works, a lot of litigation. Community care work is, challenges under the Children's Act, under and so on. Housing, a lot of challenges to evictions and that sort of thing. They're not my areas of expertise, so I won't talk too much on that. But as I say, I've come in since January as their first immigration advisor. We have an office in Hammersmith, and we also have an office in Brighton. And I'm affiliated with the Brighton office, and I'm on the South Coast now. So you may hear the odd seagull squawking in the background. Don't be alarmed. If you do need interpretation, as Sophie says, please shout. If I'm talking too fast, tell me. I was asked to talk about, the subject was advocating for asylum seekers, and that's a big subject. And I thought I would talk through the asylum process, the practicalities, the difficulties. And I hope I've got the level about right, because I don't know what you already know and don't know. And so I hope there's something in here for everyone. There might be things you already know. There might be things that you don't. Right, so.
I don't know, sorry, Gary, I don't know, Rizgar, is it worth you summarising the introduction in Arabic and just letting people know that they can raise their hand if they need translation?
Yeah.
And concise, like a sentence about Gary and who is he. Sorry.
Just briefly.
السلام عليكم. السيد جاري إخصائي ومتخصص في مسائل الدفاع أو محامي في مسائل قوانين السكن والقوانين العامة والدفاع أو دفاع عن اللاجئين وطرق الحصول على اللجوء وحقوق اللاجئين وطالبي اللجوء. إذا لديكم أي أسئلة رجاء ارفعوا أيديكم وأنا راح أترجم لكم. شكرا. Thank you.
Thank you, Rizgar. I wanted to start by talking about what an asylum claim is, what we're talking about when we're considering whether somebody should or shouldn't claim asylum, which might seem really obvious, but I think we can unpick it a little bit. Some people will be coming from countries that are very dangerous and making horribly treacherous journeys to the UK, and when they get to the UK, they will be claiming asylum as soon as they get to the port or soon after, and then they're in the asylum system. So that's pretty clear cut. They might be coming from Afghanistan, they might be coming from Syria or Eritrea. The likelihood is they're going to claim asylum when they arrive. There'll be other people who are here in the UK who are not who may have an asylum claim, may not know whether they want to claim asylum. They may be here on another basis. So they may be here as a student or a visitor, or have overstayed their visa and are considering claiming asylum. It may not be as clear cut. And that's what I wanted to think about briefly. The obvious thing to say is, if you're not sure, to try to take legal advice. Legal aid has been diminished incredibly in the immigration sector since 2012 in particular, and there's not much legal aid left, but legal aid is still in place for a person claiming asylum. That is still in scope, you can get legal aid. The problem comes from finding a provider, because there's less and less firms that are still doing legal aid, and so you may, and there's a large demand, so you may find difficulties finding a provider. And we ourselves, we want to have a legal aid contract. We don't have a legal aid contract yet because the legal aid agency have put the tendering on hold. There's no new contracts being given out. So it's a real issue. And at the moment, from LawStop's point of view, we can do judicial review claims. We are doing judicial reviews through a public law legal aid contract for immigration cases, and we can take private clients, but we don't have a legal aid contract. And as I say, I'm on the South Coast, and there's a massive dearth, a legal aid desert. There's one very good provider in Brighton, and then no others in the whole of East Sussex, West Sussex, and Surrey. I think that's the case. So there's a massive shortage of legal aid providers. But the point is, if you can, there are legal aid providers in London. If you can get legal advice, obviously that's the thing to do. Talk it through with an advisor if that's at all possible. As I say, it might not be obviously apparent when someone's claiming asylum. I was advising a transgender person recently, and he was here on a visitor visa, and he was talking through his immigration options, and she was talking through her immigration options and the difficulties that she's likely to face and return to her country. And it became apparent that she did have a viable asylum claim. She didn't know that was even possible. And after much consideration, has claimed asylum and is in the asylum process now. So that's just one example of how it might not be immediately apparent that someone has a viable asylum claim. And if you're in danger in your country, you really should be claiming asylum. So there's various ways of claiming asylum. You can claim asylum at the port of entry or soon after entry, or you can claim asylum once you're already in the country, an in-country claim at the Home Office. And I'll talk about the practicalities for making such a claim in a moment. One other thing to think about is, ideally, a person claiming asylum wants to claim asylum as soon as reasonably practicable. The Home Office take quite a dim view on claims that they deem to be late, especially if it's deemed to be opportunistic, i.e. to avoid removal when all other options have been exhausted. Their view would be a genuine asylum seeker, a genuine refugee would be claiming asylum at the first opportunity that they can. There's lots of reasons why people don't do that, and it can be explained. But the best practice is certainly to claim asylum as soon as you can, as soon as you've identified that you've got an arguable or a viable claim. There shouldn't be unnecessary delay. I put on a slide Section 8 of the 2004 Act, which actually brought into law that one thing it does is that late claims can weigh against a person's credibility. It can make it less likely that they're believed. As I say, that can be outweighed, it can be explained. The reasons for the late claim can be explained. But to be avoided if possible. There can be very good reasons for a claim being made after a person's been in the country been in the UK for a period of time. There might be a change of circumstances. So whereas when they arrived, they weren't in danger, that situation may have changed. War may have broken out in their country. There may be a political opponent where since arrival, there's been elections, the political opponents are now in power, the political opponents are treating political opponents badly, that sort of thing. Circumstances have changed. This is known as a surplus refugee, to give it the jargon. Another example would be activities in the UK, so attending protests, attending demonstrations against your home government in situations where it's known that the government may monitor such events, and through those actions the person is putting themselves at risk on return. These are hard claims, and you'd have to go some way to prove that person would be at risk, but that can be an arguable claim, and that's another example of a surplus refugee. Does anyone need any of this interpreted? How are we all doing on the interpreting front? Please do take your microphones off if you need to say anything. Please do feel that you can do that. I should say that there will be opportunities at the end for questions and answers, but if anyone's itching to ask a question that can't wait, please do feel free to chip in rather than just listening to me droning on for an hour or whatever it is.
Rizka, is it maybe worth asking people if they have any questions?
رجاء أي سؤال حتى أترجم لكم؟ رجاء هل هناك سؤال موضوع بحاجة إلى ترجمة؟ إحنا هنا حتى نساعدكم في الترجمة. شكرا. Seems no.
Seems so. Yeah. Okay. Thank you.
Okay, thank you,
Rizka. The next few slides, the next 4 slides, I want to deal with what is a refugee, what is humanitarian protection, and then a couple of other key concepts, which is sufficiency of protection in the home country and internal relocation. Now, these are quite heavy subjects and we can talk for hours on them probably. So I just want to touch on them briefly, just so we have an idea of what it means to be a refugee or somebody, a beneficiary of humanitarian protection. So we have an idea of what we're talking about. We think we know what we're talking about when we're talking about a refugee, and we probably do know, but I just want to put a bit of the law behind it, a bit to provide a bit of clarity on that. The Refugee Convention is obviously the law from 1951 that underpins consideration of whether somebody who's seeking asylum is legally a refugee. And it's worth reading out this piece from the Refugee Convention, Article 1A. So this is what a refugee is in a nutshell. Owing to a well-founded fear of persecution for reasons of race, religion, nationality, membership of a particular social group or political opinion, is outside their country of nationality and is unable, or owing to such fear, is unwilling to avail himself of the protection of that country. Let's break that down a bit. So we're looking at a person who has a fear of persecution, a well-founded fear of persecution, not just a, there has to be some serious basis for believing that they would be in danger if they go back, if they have that fear of being persecuted if they were to return. And it has to be for a reason, one of the convention reasons, one of the 5 convention reasons. So most of those convention reasons are pretty self-explanatory. So for reasons of religion, so they're facing religious persecution, or for political reasons, they're a political opponent from a country that locks up and mistreats political opponents, or they're in danger of being persecuted or treated badly because of their ethnicity or of their nationality. Those 4 are pretty straightforward. I think we can get the idea. Membership of a particular social group is more complex. So I thought I would just touch on the particular social group convention reason. It's quite a complex concept, but briefly, it's the same page. So Sophie, thank you. It's quite a complex concept, but in a nutshell, it's a group of people who have a common characteristic that is innate or immutable. So it would probably help to give some examples. There was a big landmark case called Shah and Islam in 1999, which found that women in a country that systematically discriminates against women could, and in this case it was Pakistan at that time, could form a particular social group. So women in a country where there's discrimination against women or girls who are at risk of FGM, female genital mutilation, can form a PSG, a particular social group. A family member in certain situations. So this is normally in the concept of where somebody's in danger because of a blood feud. For example, it's quite prominent in Albanian cases. So a family member who's subject to a blood feud can form a PSG. Gay and trans people can form a PSG. It's been established in law. And former victims of trafficking, someone's accepted as a victim of trafficking, they form a PSG in relation to their asylum claim. The idea is that somebody who is found to be a victim of trafficking would be vulnerable to similar treatment if they were to return. They would be vulnerable to being re-trafficked, and they can form a particular social group. So these are things to think about when we're thinking about, you know, am I a refugee? Is the person I'm assisting a refugee? Do they have a claim? The next slide is humanitarian protection. This is essentially protection for people who are in danger if they return to their country, but they don't meet the Refugee Convention, normally because they don't have a convention reason. So substantial grounds need to be shown for believing the person, if returned to their country, would face a real risk of serious harm, and can't get the protection of the state in their country. And serious harm, you'll see on the slide, is defined in the immigration rules as, well, the death penalty and unlawful killing. And then number 3 here, torture or inhuman or degrading treatment or punishment of a person. And the 4th one, serious and individual threat to a civilian's life or person by reason of indiscriminate violence in situations of international or internal armed conflict. The 3rd one, eagle-eyed people will probably spot that mirrors Article 3 of the European Convention of Human Rights. So somebody who is liable to face an Article 3 breach if they were to return to their country, but doesn't have isn't a refugee. And the 4th one comes from the Qualification Directive, which is a legal instrument that tried to create a common concept of when somebody needs international protection across the European Union, and it is still relevant post-Brexit, that legislation. It was retained in the Withdrawal Act. And sorry, this number 4, the threat to a person's life, this is where there's a very dangerous situation in the country, civil war, and it's accepted that a person just by going back to that country would be at risk, essentially. It's been found in law to apply in Syria and parts of Yemen, but not all of Yemen, as I understand it. I think that's still the case. The Home Office will try to argue that half of Yemen is relatively safe. I think the asylum-seeker and their representatives may have counter-arguments to that. It doesn't apply very often. It's a very high test, the serious and individual threat in a civil war context. It rarely applies, but it does apply sometimes. So that's humanitarian protection. The next concept, the next slide, Sophie, thank you. The next slide is, it's 2 other concepts. If you're going to succeed in either, if you're going to convince a decision maker that you're a refugee or that you're entitled to humanitarian protection, you've got to get over these 2 important things, which is you may well have a fear of persecution if you go back, but can the state protect you? That's the first concept. It's known as sufficiency of protection. If you're afraid of the state, if you're a political opponent of the state, if you're being persecuted by the state because of your religious beliefs, you're not going to get protection of the state. That's pretty straightforward. But what if your fear is of a non-state, what's referred to as a non-state actor, such as a criminal gang who has political connections, perhaps. I talked about the concept of the phenomenon of blood feuds in Albania. There's some debate as to how prominent it still is. The Home Office argue that it's not very prominent. Human rights reports suggest in certain parts of the country it still is, that there's a debate to be had there. But if you're returning, you're not fearing the state, you're fearing another family who you have a blood feud with. I'm hearing a voice. Was somebody trying to come in with a question, or was it just background noise? You're welcome to. So in that case, the question is, can the state protect you from the other family? Can the police force, the judiciary, is there a sufficient judicial process? Is there are the police actively sufficiently trying to stop that sort of thing happening and taking it seriously? Again, the Home Office and what the human rights reports say often differ on this point, and you'll get into a debate about that. What the law says, there's a big case in 2000 called Horvath. So it's often known as Horvath sufficiency is what has to be shown to be in place. And it's not required that the state provide protection for every person all the time. It's accepted that can't be achieved, or can't be expected to be achieved. What is expected is that there's a sufficient level of protection, that there's systems in place that provide protection. There's a active police force, as I say, a judiciary in the country of return. And then you get into questions of, well, are these systems effective? Are they corrupt? Are there links between the non-state actors who the person fears and the state? And that's where you'll get into conversations with the Home Office or with an immigration judge. The other concept, so that's sufficiency of protection. The other concept is internal relocation. So if you're in danger in the area that you're from, what about moving to another part of the country? Is it a big country? Is it a small country? Again, if you're in danger of the state, you normally won't have an internal relocation option. That won't be expected that you can move to another part of the country. If you're so there's two considerations. If it's argued that you can move to another part of the country, the question is, will you be safe in the other part of the country? Do the people that you fear have the reach, the connections, will they know that you're back? Will they know that you're in another town, another large town? The Home Office, Afghan cases often argue, well, it may be dangerous in your province, but there's no problem moving to Kabul. Again, the asylum seeker and their representatives may have a different view on that. But so it's a question of, is it safe to live in another part of the country? And if that's the case, is it reasonable, or in the jargon, is it unduly harsh to expect a person to do so? Would it cause unreasonable practical problems for that person in terms of establishing a reasonable life? Again, Afghanistan is a good case. Will you be able to find work if you move to a remote area where you've got no family support, no connections, no support network? These are questions to be considered. So as I say, this is a very big subject, but I just wanted to give you an overview. So we're thinking along the right lines when we're thinking about whether someone is a refugee, whether they have a viable claim. So I hope that's given you something to think about. But I'll move on to more practical stuff now. So what's the process? Let's just sort of walk through the process. Somebody claims asylum. They may have claimed asylum at the port of entry, as we were saying before, but if you're already here in the UK and you're claiming asylum, what do you do? In the first instance, you telephone the asylum intake unit, and there's a number on there on the government's website. They'll take a few details on your telephone number, and they say they'll call you back within 48 hours, but I think recent experience is it's a lot longer than that. I had a client recently who was messed about a bit, actually. He phoned, and then when they realized his visa was nearly expiring, they said, come down to Croydon, to Luna House, the big Home Office building. It will be quicker that way. I think having later spoken to the woman that they spoke to, I think she was actually trying to help, but it got a bit messy because he went down to Croydon and was turned away. And then he was told to come back the next day and was turned away. And eventually, the same woman on the helpline arranged for someone to call him to make an appointment. That's probably what should have happened in the first place. I illustrate this just to say it's a bit chaotic at the moment. But the first instance, phone, tell them you want to claim asylum, and then follow the process, which will probably be somebody calling back within some days, and inviting the person to a screening interview, which is the first event along the process. Sorry, same page, Sophie. Thank you.
Sorry.
No worries. I just wanted to point out that when someone claims asylum, they're liable to detention. That doesn't mean that they will be detained. It means that they can be detained. Most people who claim asylum won't be detained. And the reason for that is, firstly, the Home Office have limited resources, only have limited space in their removal centres, but also they have to justify detention. And one of the key concepts in considering whether somebody should be granted bail is whether there's imminency of removal. Is somebody likely to be removed soon? And we know, I think, how long the Home Office are taking with asylum claims, how long the whole process is, the whole, asylum claim, possible appeal. These aren't quick processes. So if someone's got a viable claim, a vaguely substantial claim, the Home Office will recognise that that's not going to be a quick process, and they will generally, unless there's particular specific concerns about the person absconding, will grant. Used to be a temporary admission. It's known as immigration bail now, actually, which means it's not a form of leave. It's not an extension of any leave. It's a kind of tolerance. It's saying you're allowed to be in the UK whilst your claim and any appeal is being considered. You can't be removed from the country during that process. So a person will normally get bail, even though they've never been detained. They'll be granted the concept of bail, and possibly be required to report, often will be required to report and sign on at various intervals for every 4 weeks or whatever it is, as an alternative to detention. I say that not to put people off or scare people about detention. It's more the opposite, to say that it's unlikely to happen, but you need to be aware that it's a possibility, that the government do have it within their powers to do that. I mean, if it is at the beginning of an asylum process, then you're likely to have a strong case for bail, even if you were to be detained, but it's very unlikely in most circumstances. And yes, and then we move on to the screening interview process, which will be the next event. And that is the next slide, Sophie, thank you. So it's yes. So you've made your asylum claim, and then you have certain permissions or certain rights. You don't have, an asylum seeker doesn't have a lot of rights, unfortunately, but there are some things to bear in mind. An asylum seeker is allowed to study, but it's a bit of a hollow right, if you want to use that word, because they'll be subject to overseas student fees, so the very high student fees, and they're not permitted to get student finance. That persists until the point that they're recognised as a refugee, if their case succeeds. So at this asylum seeker stage, you are allowed to study, but you have to have the money to fund it, unfortunately. And there's nothing to stop the asylum seekers' children attending school, and there's nothing to stop a person registering with their GP. Anyone can register with a GP, irrespective of immigration status. That's really important. Most people with insecure immigration status can't get secondary medical support, hospital support, or rather they can do, but they're liable to be charged for it. But that's not the case for asylum seekers. Asylum seekers, if you're claiming asylum, you can be given hospital treatment without then receiving a bill. Or if you do get a bill, and sometimes they get this wrong, if you explain that you've got an asylum claim and prove that you've got an asylum claim, they really should ditch that bill, get rid of that bill. You shouldn't be paying for any NHS medical treatment. An asylum seeker, generally speaking, can't work, isn't permitted to work. Given the amounts of time they're taking to deal with asylum claims, it's a thing of much frustration, and I know from my clients, some seekers just want to be able to try to find a certain stability, normality in their life, and be able to work and support themselves. No permission to work, though. There are exceptions. If somebody already has a form of leave to remain that allows them to work when they claim asylum, that will generally be continued. I think the Home Office can take it away, but they generally don't do that. So providing you make your claim before your visa's run out and you were allowed to work, then that carries on, that continues. Another thing to bear in mind is that after, if the asylum claim has been pending for more than 12 months through no fault of the asylum seeker, providing they haven't delayed attending unreasonably delayed attending interviews or some such. It's not normally the case. The delay is normally down to the Home Office. So if you've been waiting for over 12 months, and that's also true of a fresh claim from when the fresh claim was submitted, you can apply for a work permission. You'll normally get it. The problem is, though, that it's not full work permission. It's limited to shortage occupations only. The list of shortage occupations are found in the immigration rules. They change from time to time. But often that, for a lot of people, it means effectively is a ban, because they're not qualified to do many of the jobs in the shortage occupation list. I couldn't just rock up and apply to be an engineer or a scientist or a what else is on the list? Doctors. I mean, it's quite a long list. It's worth checking whether that would be helpful to the asylum seeker. But generally speaking, it's not great. It's not of much use. Oftentimes, there have been a couple of higher court cases recently which have criticised the government for not allowing exceptions from that rule. I mean, to give full work permission after 12 months. And what they've been told by the courts is that they have to give more consideration on a case-by-case basis to whether there are exceptional circumstances as to why they should give that work permission. And so they've been given a bit of a slap on the wrist, but nothing much has changed. The policy, I think, does now say they have to consider whether there are exceptional circumstances, but that full work permission will only be given in very rare circumstances. So in practice, I don't think there's going to be, at least for the time being, a great shift on that. But if someone is has particularly stark circumstances over and above other people, it's worth testing this, isn't it? And worth trying this with the Home Office. The other thing, of course, you probably know about is that if someone claims asylum subject to a means test, they can apply for asylum support. So they get basic accommodation and subsistence payments, the voucher scheme. So it's not voucher scheme anymore, it's on a card, the Aspen card of subsistence payments. Let's move on. So someone's established their asylum claim. The first thing that they'll be invited to do will be to attend a screening interview. These will be basic questions about, for example, how they came to the UK. Did they stop at any other countries on the way to the UK? How did they arrive in at the UK? About their family details. They ask about their level of education. And they do touch on why the person's claiming asylum. They don't go into any detail, and you don't need to go into any detail at that point. But what is it that you're afraid of on return? What is your fear of persecution? In a nutshell, it's best not to go into too much detail. You don't need to go into too much detail. You're not being invited to go into too much detail at this stage. And then the asylum seeker or their representative will be provided a transcript, a copy of the transcript of the interview. They'll also be given, this is a relatively new process, although it's been around for a while now, they'll be given, or their representative will be given a PIQ, which is a preliminary information questionnaire. And they're expected to return that within, they're given a date to return it. And the questionnaire asks more questions about why they're claiming asylum. And I think how you complete that is a judgment call. You can either give detail or you can refer to a person's witness statement or the representative's accompanying letter, so you can, see attached, see attached, see attached. If you don't want to complete the PIQ in detail, that's what will often be the case. Or you can complete the PIQ in more detail if that works best. So I mentioned a witness statement. So that's something that if a person, so the next page, Sophie, thank you. The witness statement is something that can be provided as a form of evidence in support of the claim, usually done with a person's legal representative. And it will set out, in the claimant's own words, in the asylum seeker's own words, their background. These are examples, so there's no rights or wrong here. You would tailor it to the particular circumstances of the case, but you normally set out their background. This is an important thing, isn't it? What's forced them to leave their country? So tell a story about what has happened, explain chronologically what has happened, what forced them to flee, the journey to the UK, and then what's happened since they've been in the UK, in terms of their immigration history, when they claimed asylum, if they've had other visas, explain the dates and what they've had, why they claimed when they claimed. As I was saying, the timeliness of the claim is significant, so that if it's an issue, that needs to be it's worth addressing that in the statement. And then you'd want to round off by explaining why they can't go back to their country, what they fear, what they think will happen to them. And it's good at this stage to address those key concepts that I was talking about. Protection, why can't the state offer protection in the asylum seeker's own words, their own view? Why can't you go and seek the protection of the police? Have you even tried that? Were there efforts to contact the authorities before you left, or was that just out of the question? And why not? And the consideration of whether you could live in another part of the country for your safety, whether you'd be safe, whether it's reasonable to do so, what are the practicalities of doing so. And then, this is quite difficult, I think, because every case is going to be different. Different people have got different views on this, which is when to submit the witness statement and whether to submit a witness statement. Most asylum claims, the Home Office refused most asylum claims, and most asylum claims are refused on credibility issues. They're not believed. And the Home Office will pick up any discrepancies, whether, reasonably or unreasonably. And so the more times a person's told their account, the more opportunities for discrepancies arising. If you're a newly arrived asylum seeker, your things don't come out. When you're being asked questions, things don't come out easily in one go. Things do get confused. People who've had traumatic experiences, may find it difficult to open up, may be confused about what happened. There's all sorts of reasons. So discrepancies happen and they need to be explained, but we want to minimize. We don't want to create more confusion with a witness statement that says something different again. On the other hand, I think it's a great exercise to do, even if it's not submitted, because it helps the claimant, the asylum seeker, get things out of their head and onto a page and make sense of their history. And it might be the first time that they've had the opportunity to do that. It's better that if the first time is happening with their legal representative rather than in a Home Office interview. So I think it's a good thing to do. And I generally do think it's helpful to submit it often, and that's often before their main interview, which is the next interview, which I'm going to be coming on to talk about. So yeah, it's a bit of a judgment call, basically. Every case is different. But I think witness statements are probably one of the most helpful and important. A good statement is the most important and helpful thing for an asylum seeker. Get a good statement, get things nice and clear, and explain in their own words why they're at risk on return. Let's move on. I don't know how we're doing for time. Gosh, it's already nearly 11 o'clock. So there's the substantive interview. There may be quite a long wait for the interview. The Home Office, as I say, the whole process is very slow. You'll eventually be interviewed. I think these are often still being done remotely by video camera, but that may be starting to change. So this will be a lengthy interview with the Home Office representative, where a person's asked a lot of questions about why they're claiming asylum. The person will already have an idea of why they're claiming asylum from the PIQ that's been submitted, or the witness statement that may have been submitted, or from representations from the lawyer. So they're going to ask questions around that, around what they already know, ask for more detail. They might ask for, they often ask questions about the person's home country to establish if they really are from that country. So they'll, give you a quiz about the currency, the rivers, all sorts of things that they've got off Wikipedia or wherever. If your claim's based on religious conversion, they'll quiz you on your religious beliefs. They'll ask you questions about the Bible or whatever. So be prepared for that. The legal representative doesn't, generally speaking, attend the substantive interview. They can do, they're allowed to. You normally have to request the attendance in advance. The legal representative doesn't normally get legal aid for it, though, so that's why they don't attend. They can get legal aid to attend for unaccompanied minors and where a person is particularly vulnerable. So you can get legal aid for it. You can attend. The legal rep can attend. Generally speaking, they don't need to. The other thing I was flagging up here on the slide is make sure that the asylum seeker and the interpreter, if there's an interpreter being used, understand each other. There's so many cases you come to further down the line where there's things that have been misunderstood. The asylum seeker is saying that the interpreting wasn't good. It's a Home Office provided interpreter. So it's really important that the asylum seeker is brave and says if things aren't working, if things aren't being understood, and asks that the interviews just either different interpreters found, that might mean postponing the interview, but it's really, really important, clearly. So don't soldier on if you're not being understood. This might be obvious, but an open and honest approach as much as possible is to be encouraged. An asylum seeker may have good reason for being wary about the person interviewing them, and be quite closed about what they reveal. It's really important. As I said, credibility is the key, the most important thing. It's so important that the person is open, answers the questions openly and fully, and honestly as possible. And it's so tempting, and I understand why, to exaggerate a claim because they want to be believed. Something terrible has happened to them, but they don't think that might be enough for the Home Office, and they exaggerate and add in something else, and then it all unravels, and there's contradictions, and then they're not believed, and then you've got an uphill climb. honest and open. That's the approach. And again, a transcript will be provided to the representative. And then the next slide, really important, you have a meeting with your, or a telephone conversation or some sort of conversation with your representative after the interview. The representative's given 5 working days to provide any further evidence, and that can include written representations. If you want to provide the statement at this point, that's fine. It's not hard and fast, 5 days, but you want to try and stick to it, or if you need more time, ask for more time. It's not like the whole case is going to be struck out if you don't get it in on 5 days, but it's good to meet it. And as I say, let them know if it's going to be late. It's really important to have a conversation with your representative who will have read the transcript. And if anything's not adding up, if there's confusion, if there's things that need to be ironed out, it's really important it's done at the earliest stage. It's done now. So as I say, the representative can write to the Home Office and they can explain confusions, things that need to be put right. If it's that bad, you might even need a supplementary statement. Not usually, but that can be done if necessary. Let's crack on because we don't have so long. Doesn't time fly when you're? So you'll have a long wait. I must say, delay, exceptional delay, and it has to be pretty exceptional, and there has to be prejudice to the client. If you've got a particularly vulnerable person who the exceptional delay from the Home Office are meant to decide a claim within 6 months. It rarely happens. It's normally a lot longer than that. But if it goes on extremely long time and it's been followed up by the representative or the asylum seeker, been chased up, not getting anything, no time scale, the claimant has mental health problems and it's exacerbating those problems. For example, you might want to consider starting a judicial review process. As I say, we do judicial review claims. I think the courts don't take too kindly to delay claims because they give the Home Office so much discretion, so much leeway. It has to be pretty extreme, but it can be helpful to start the process. A pre-action letter, at the very least, you'll get a response. It gets the case looked at. You might get a timescale. You might get it bumped up the queue a little bit, but it has to be pretty extreme. Delay is kind of baked into, unfortunately, is what's accepted. It's not good, but that's the way it is, I'm afraid. So you get your decision. It's a good decision. You've been granted your leave. It's either refugee status or humanitarian protection because they accept that you're at risk if you go back. So you get 5 years. You get granted 5-year status, refugee status or humanitarian protection. There's not a great deal of practical difference between the two statuses. There are small differences, but in most practical terms, it's the same. You get a 5-year document. You can apply for indefinite leave to remain after 5 years. These applications are generally straightforward. They're generally granted. It's normally a straightforward application. The government have, from time to time, made noises about actively reviewing the case before granting indefinite leave to remain. They do have a policy. They can do that. Is the person still at risk? Is the country still dangerous? In practice, the Home Office did say that they were going to have policies for individual countries where the situation changed. It's now perfectly safe in their view to return. They haven't had, to my knowledge, policies on any countries in terms of a change of circumstances where they'll no longer continue to accept somebody as a refugee. So generally speaking, your case won't be actively reviewed and it will be rubber stamped effectively with ILR. That's my practical experience, except where somebody has a pretty bad criminal history, and then they will take a different approach. It seems strange, either somebody's at risk or they're not, but they do take this sort of two-tier system where they will look at the country situation, where there have been circumstances where this has happened, where they'll look more closely at the country situation or any change of circumstances when they come to do ILR for people with criminal histories. It depends on the country. There would have to be pretty significant changes in the country circumstances for them to justify no longer accepting somebody as a refugee. And generally, ILR is granted, ILR as a refugee, indefinite leave to remain. And then that person will qualify to naturalize as a British citizen. There's various qualifying criteria, but either immediately on grant of ILR if they're married to a British citizen, or after 1 year if they're not. And there's other criteria to be met, like the life in the UK test. Just one thing I would caution on in terms of naturalization, the good character requirement now is so strict and applied pretty rigorously by the Home Office for naturalization, that one thing to consider is, the person might not have any criminal history, but they have to have been within the immigration rules, no breaches of the immigration rules within the last 10 years. If they've been an overstayer in the past, you need to complete 10 years of lawful residence. That can include the temporary admission. So from when they've claimed asylum, if they subsequently get refugee status, that's okay. But it's the period before where they possibly been an overstayer. If they haven't claimed asylum immediately on arrival, for example, that there might be questions. So just be careful on that, not least because it's a very expensive application that will be where the money will be lost. They may be granted on another basis, such as on family or private life grounds. So you get limited leave to remain. So we don't accept, this is the Home Office, we don't accept that you're a refugee, that you're in need of international protection, but we do accept that there's family or private life reasons why it wouldn't be proportionate to expect you to return, or discretionary leave. That discretionary leave is used much less these days by the Home Office. It's used mostly in relation to somebody who has a claim on health grounds, that they're very, very seriously ill and that they would deteriorate and or die very quickly if they return to their country because there's no medical treatment, which is a very high threshold to meet. If you do succeed on that basis, even on Article 3 grounds, you'll get discretionary leave, which is normally 2.5 years, both of these, family and private life and discretionary leave, 2.5 years. Victims of trafficking also may get discretionary leave. And you normally have to complete 10 years before you get to the indefinite leave to remain point. Okay, let's move on. Unfortunately, as I say, most asylum claims are refused by the Home Office. There is much higher success rates. A lot are overturned on appeal. And I think you need to think about that when you're claiming asylum. You need to assume the Home Office are going to refuse your claim and be preparing for an appeal. I mean, that's not going to be the case in every case, of course. But you need to be thinking of preparing yourself mentally for having to go through the appeal process. Sorry, we're on the next page, Sophie. So you have 14 days to lodge an appeal. This will be done by your legal representative in most cases. There's a new process now where it's done through a government portal to lodge the appeal. If you're unrepresented, though, you can still do it the old-fashioned way online, and I think you can still do it by paper form. And there's a new process, the appeals process, whereby it's quite complicated, but in brief, you submit your supporting evidence, the bundle of papers, with the lawyer's skeleton argument, arguing your case at an earlier stage than we have done in the past. An earlier stage of the process. It goes to the Home Office, it goes to the court. The Home Office then have a period of time where they can meaningfully review the claim in light of these representations and evidence, and they can, in theory, overturn it. My initial experience of this process is that there wasn't much meaningful reviewing going on, and they were rubber stamping their original decisions. So that's disappointing, because I think it's a good idea in practice, and maybe things will improve, and maybe are starting to improve. So you can have the Home Office can overturn their decision before you even get to court. Then you go to court. I think that the default position is still a remote hearing because of the pandemic. You can request a hearing, a socially distanced hearing in person, and I think gradually they're going to be having more and more hearings back in the tribunal. So I suppose it's a judgment call, depending on the client and their vulnerabilities, as to whether you request that in-person hearing. I don't know. I had a client towards the end of last year, I think it was, who was very, very vulnerable, a client of freedom from torture, very traumatized. And with his support worker, we were trying to decide whether to ask for a hearing in person. And it ultimately came down to, we left it to him to decide in the end. He wanted it on the screen. He felt more comfortable with that. So I guess it's not always obvious. And there's no right or wrong answer, but it's something to bear in mind. Again, it will be a judgment call. And then an independent judge will make a decision on whether the person should have been refused, or whether they're a refugee or in need of protection, international protection. And they will provide their decision after hearing from both sides at the hearing. If the judge dismisses the case, whatever the decision, the other side has 14 days to appeal. So if you win, you've got to hold your breath and wait to see if the Home Office try to take it to the upper tribunal. And if you lose, you have 14 days to apply to the upper tribunal. That's not automatic. You have to apply for permission on a point of law. It's not that you don't like the decision. It's that the judge has to have made a material error of law, has to have made a mistake in law. And you apply first to the first tier tribunal for permission to the upper tribunal. If that's refused, you get a second bite of the cherry. You apply for permission to the upper tribunal. And if that's refused, your only remedy will be judicial review if there's grounds to do that. If you're permitted into the upper tribunal, this is complicated, isn't it? And then your hearing's heard in the upper tribunal, but you still lose, your next port of call will be to the Court of Appeal. Very few cases will go that far. For the Court of Appeal, to get permission into the Court of Appeal, there has to be an important point of principle or practice or some other compelling reason for it to be heard, over and above the error of law by the upper tribunal to not find an error of law from the first tier tribunal and the mistake of the first tier tribunal. So you're going to have a battle on your hands, but some cases obviously do go on, and that is possible. So I wanted to talk, it's already 11:15. I just wanted to talk very briefly then about certified decisions. You may get an asylum decision, there's no right of appeal. That's because the Home Office deem it to be clearly unfounded. It's a high test for them to meet, because it has to they have to justify that on any legitimate view. And leaving aside credibility issues, we'll take your case as if we believe your case. And even then, it's got no chance of succeeding on any legitimate view. If it came before a judge, it would fail. End of story. That's what they have to be saying if they're certifying the case as clearly unfounded. This is not, just to be clear, this is not a literal certificate. It's in the decision letter. They will say, we're certifying your claim and you don't have a right of appeal. And so the only remedy is to judicially review the fact that you haven't got a right of appeal. So you're trying to get yourself a right of appeal by taking them to court over the fact that they haven't given you a right of appeal. I hope that makes sense. We do these judicial reviews, these types of cases. So if you see a case like that and want some advice on it, please get in touch with me. And so if you succeed in your judicial review, if they back down, or if it goes to to court and you win, you will then get a right of appeal, and then you're back to lodging your appeal. I do have a couple more slides. I've taken longer than I thought. I wanted to talk about bail hearings and fresh claims, where somebody has completely exhausted, or they've been refused, or their appeal rights have been exhausted. If you want to take the case forward after that, you have to provide new evidence. You can't make a new asylum claim. You have to make a fresh claim. But I won't talk about it now. I'll let you look at the slides, and if you have questions, you can always contact me whenever you want about anything. And I better leave a bit of time for questions. So does anyone have any questions? Can I come back in 2 seconds? Thank you.
Great, thanks for that, Gary. That was really, really useful, really informative. If anyone has any questions, please feel free to write them in the chat, or just to shout them out, or if you'd like any translation, please let us know, and Rizgar can provide it.
رجاء رجاء أنا موجود للترجمة. إذا ما محتاجين الترجمة أنا موجود. شكرا. Thank you.
Thank you. And I'm just going back to the bail slide, which was requested by someone.
So sorry, I'm here. Were there any questions at all? Hi, Tabby. Is that Tabby?
Yes.
Hi, Tabby.
Hi.
How can I help?
Sorry, I'm in the garden. I've seen the weather forecast for the next week or so, so I'm making the most of it.
It looks fantastic. It looks fantastic.
Thank you for that, Gary. That was really interesting. I really appreciate that. I've worked in refugee resettlement for most of my career, but outside of the UK, I've been based in Asia, and just recently back in the UK, so trying to get up to speed with things here. So that was really informative. I did have one question. You said that most claims are denied, but then subsequently a much higher number are overturned at appeal. So I'm just wondering, do you have any specific statistics?
I don't have
what percentage?
Yeah, I don't have the stats on that, I'm afraid. It used to be the case that, in terms of the appeals, it used to be said that it was about 1 in 5 or 1 in 4 would be overturned. But we used to, used to have a better record ourselves on that. But overall, I think it was, I did hear not so long ago, it was closer to 50%. I'm not going to give you statistics because I don't have them, but it's quite, and just from personal experience, it's a different ballgame when you get into the, when you get to that stage, when you get to the independent tribunal, because the Home Office have very sort of set ideas on things and set lines that they take, and you just know that they're just not going to provide a nuanced or even a very good sometimes decision. Whereas when you get to the tribunal stage, you're, it's being considered properly, quite frankly. And often the presenting officers, so the people representing the Home Office in tribunal, can sometimes see that. They're sometimes embarrassed about defending their own decisions. And they're often not allowed to withdraw their decisions, so they have to sort of suck it up, as it were. And the other thing to bear in mind is, because of the way legal aid funding works, you often can't justify funding for detailed expert reports until the appeal stage. So country expert reports, medico-legal reports, such as from Freedom from Torture. You can sometimes justify that at the earlier stage, but you're normally getting that at the appeal stage. So there will be more evidence, perhaps, by that stage.
You mentioned Gary. Good character.
So sorry, I don't have the stats for you, Debbie. But does that help you at all? Does that?
Okay. Yeah, it does. I guess it just seems, I mean, I realise I'm preaching to the converted here, but it just seems, a bit ridiculous and not a good use of anyone's resources, not the Home Office's resources, if they're sort of wasting all that time overturning, poor decisions in the first place. And I'm just, as I said, I'm just getting back up to speed with the UK situation. And
it's often not taken seriously until you actually get to the courtroom. For example, that guy that I referred to, who was particularly vulnerable, Freedom from Torture client. It was a terrible decision in the first. It was a fresh claim. It was a terrible decision in the first place.
Neutralization.
We then went through the appeal process, the new appeal process, where they're meant to meaningfully review it. We got a one-line answer. We then asked again for it to be reviewed, and it wasn't. And then when we came to court, the presenting officer was like, "This hasn't been reviewed." I mean, she could see that it was a bad case from their point of view. And so the point I was making about the guy having to do it remotely, he ended up not having to give evidence because it didn't go ahead. It did waste everyone's time. They went away and reviewed it, and they gave him refugee status. But it took all of those steps to get to a point to see that this was a very deserving recipient of refugee status. So I think we're all a bit institutionalized with the way the system works, but you're dead right to highlight it's a waste of everyone's time and resources. Often, yeah, it is shocking.
Okay, thank you for that, Gary.
Thank you, Tabby. Thank you. Anyone else have anything to ask or to say? I mean, you probably have experiences. Can tell us things that I can't. So, do you have any comments as well as questions?
Sorry, I came too late. But if you can give us summary for this.
I'll do it all again. No, well, what we covered was the asylum process step by step. I'm an immigration caseworker, so I was just talking from my experience of representing asylum seekers through the process and things to consider. But I don't know if is Sophie, are we intending to share the PowerPoint?
Yeah, so we are actually streaming the presentation on YouTube. So what I'll do is I'll drop the link into the chat, and then you can access the recording. because yeah, I know you had a few connection issues, so you can watch the whole session back.
Yeah. Yeah.
Did you record the meeting today?
I'm so sorry, I didn't catch the beginning.
Did you record the meeting, this meeting today?
Yeah, I believe it's being recorded on YouTube.
Can I have the recording?
Yeah, I'll put it in the chat now.
Thank you, my dear.
There you go. I've just put it in, so you should be able to access it now.
Yeah, I hope the presentation is helpful. It's more of a note to self, but maybe there'll be information in there that will be helpful. And if you need to contact me directly, my email address is garyg, and then at lawstop.co.uk, garyg, if that would be helpful.
So did you say at org.uk or at .co.uk?
.co.uk, lawstop.co.uk.
Okay, I'll just put that in the chat as well.
Thank you. Is there any other questions at all? As I say, I didn't quite know how to pitch the level, so I hope it was helpful to some of you at least, or some of it was helpful. Is there anything else that you need to know? Anyone?
I guess if if no one else has any questions, maybe what would be helpful is if someone is in need of kind of some legal advice on kind of claiming asylum or their immigration status, what would you kind of advise them to do as kind of the first steps? How can they take action on that?
Yeah, I mean, as I was saying earlier, take legal advice, obviously, is the way forward. Find a legal aid representative. There are good legal aid representatives. Be wary of, obviously there's a lot of good solicitors. Be wary of paying privately for a solicitor who doesn't specialize in immigration law, because we do see so many cases where cases haven't been dealt with well, and it can cause more damage than good. Of course, there are a lot of very good solicitors too. I should say that. But legal aid solicitors specializing in immigration law, there may not be, it may be hard to find, and you may have to keep trying and be persistent. There's big firms, Wilson & Co, Bindmans, Ssufficiency and Hartigan. These are all good firms with good reputations, but probably demand, capacity is often going to be an issue, unfortunately.
Yeah, thank you. That's really helpful. Do we have any final questions before we close the session? And as I said previously, so I've dropped the link to the YouTube video, so you can watch the session back. Gary's very kindly given his email address, so if you do have any follow-up questions, yeah, please feel free to get in touch.
That's fine.
But I just wanted to say a big thank you to Gary and to LawStop for facilitating this session. It's been really, really informative, really helpful, and yeah, a great way to mark kind of our Refugee Week at Hammersmith and Fulham.
It's been a pleasure today, and thank you for having me. Thank you.
Great. Thank you so much, everyone, and enjoy the rest of the sunshine.
Thank you very much. Have a good day.
Bye-bye.
Thanks. Bye.
Bye.
Thank you.